Good afternoon, and welcome to the afternoon Zoom session of the Court of Appeals. I'm Judge Arnold Golden. I'll be presiding this afternoon. I'm joined on the panel and I'm from Memphis, by the way, and I'm joined on the panel by Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah. Although I'm sure y'all have been here before and you understand how this works, I'll just mention that the appellant, each side gets 15 minutes. The appellant can reserve up to 5 minutes for rebuttal time if you choose to do so. And just let us know when you start how much time you would like to reserve. I understand that the appellees will be sharing their time. So when you'll have to let us know when you come up how much time each of you will take. You can share the 15 minutes however you would like. All right. Mr. Clerk, will you please call the docket?
Ezra Maize versus Friendship Community Church, Inc. et al.
Mr. Weiss?
Okay, that's my cue. Good afternoon. My name is Joshua Weiss, along with Samuel Quattrotri of the Chattanooga Bar. We represent the plaintiff appellant, Ezra Maize. I respectfully request 3 minutes for rebuttal.
All right, sir.
May it please the court. This is a case of very interesting law. There are a lot of causes of action in this case, but what I want to make certain is what the gravamen of the plaintiff's complaint is. The plaintiff is not, this is not an employment case. The plaintiff is not seeking relief for an improper employment termination or anything of the kind. This case is specifically about the appellees abusing the process of the court to accomplish an ulterior, malicious motive. And they did so by slandering and committing other acts of defamation against the plaintiff. For a bit of background, the plaintiff in this case, his name is Pastor Ezra Maize. Ezra Maize was the senior pastor or the pastor of intent at Friendship Community Church. He was a pastor there for approximately 3 years. At a certain point, it became known that the elders of the church were acting corruptly, dealing among themselves with obvious conflicts of interest. Our client, Pastor Maize, went into the church to try to stop these abuses. When he began this process, he met with obvious resistance. There was a battle for control of the church. And in an effort to sideline him, to stop him, the church and its ruling board of elders accused Pastor Maize of quite a few allegations, and the most serious of which are they accused him of being a child molester. They accused him of having inappropriate relationship with underage girls. They made it known throughout the community. The main basis of, or the main person behind this defamation was a gentleman named Vincent Boozer. He was the assistant pastor. It is our belief that he wanted to acquire the senior pastorship himself, so that way he could receive the pay that the senior pastor would make. The ruling elders then conspired together in order to stop Pastor Maize from stopping these abuses. They held 2 different meetings where they conspired together to falsely defame Pastor Maize. When that did not work, they filed a motion in a temporary restraining order, an injunction in the Chancery Court of Hamilton County. Chancellor Fleener in that said that she wanted to avoid the ecclesiastical abstention doctrine. But it is from that document that they filed that put these allegations completely out in the community That's where the Chattanoogan, a local newspaper here in Hamilton County, picked up on the story from those filings. From that point on, Pastor Maize, our client's reputation, was horribly tarnished beyond repair. When you're a pastor of a church, when you're a social worker, being called a child molester, there's no coming back from that. So in response, the plaintiff filed this action. And I understand that this is our first trip to the Court of Appeals. This matter has been going on for 5 years. In those 5 years, there was 5 different motions for summary judgment that eventually was granted to the appellees in this matter. We went through about 4 different trial court judges. The first judge retired and went through a few other judges, and all recused themselves. And finally, it was transferred to Division 4, Judge Kyle Hedrick. Judge Hedrick is the one that ruled entirely for the defendants, the appellees here, giving them summary judgment. The issue in this case is there are obvious, genuine issues of material fact that would preclude a summary judgment. And as the court is well known, that this is, the court should find in the non-moving, in the light of the non-moving party. And here, let's deal with the low-hanging fruit, the abusive process claim. That was a verified complaint filed by Elder Blake on behalf of Friendship Church. It is a verified signed complaint by him. That was not filed to protect the church. That was filed to keep Pastor Maize from taking over the church. That was a malicious and ulterior motive, not meant for the purpose of the court, not for the purpose that was stated in the verified complaint. And it is shown by the court's order. It was meant to protect the church from underage women from being violated, among other things. At his deposition, Elder Blake said, well, the only reason that I filed the injunction was because Pastor Maize had a temper and I was afraid there would be violence. That's not the reason that's stated in the verified complaint at all. That was the means of using defamation, and the ultimate goal, the ultimate motive was to eliminate Pastor Maize as the pastor of Friendship Community Church and to make him leave town. And they succeeded. There is, without question, issues in this case, especially with the abusive process claim, that would make one believe there's no other reason to file the injunction other than to embarrass, harass, humiliate Pastor Maize. No reason for it. Other issues in this case included intentional and negligent infliction of emotional distress. The trial court found that the negligent infliction of emotional distress claim failed because there was no expert proof. We believe that ruling is incorrect because we believe that the negligent infliction of emotional distress claim does not require expert proof when it is parasitic to another tortious claim or tortious conduct. Here we have defamation and abusive process. And then of course the intentional infliction of emotional distress or outrageous conduct, we believe that was proved outright, and we don't understand how there are no genuine issues of material fact that the court could find that would or couldn't find to make the ruling for the appellees.
Let me ask you about the negligent infliction of emotional distress. If we were to find that the defamation claims could not go forward because of the ecclesiastical abstention doctrine, then what claim would it be parasitic to?
Abusive process.
And what is the basis of the abusive process claim?
The basis of the abusive process.
You've waived the malicious prosecution claim, I think.
Right. Unfortunately, we had to waive the malicious prosecution claim, and in reality, it actually shows the abusive process claim even more, because once the appellees filed the verified injunction and complaint, that basically was out for 2 weeks. And then before our client could even respond to that, it was dismissed with prejudice. Because there was no finding on the merits in this case, according to precedent and case law, we don't believe that there was any malicious prosecution. But an abusive process here, I don't think that there's any question that there was an obvious ulterior motive. But then the question is, what was the purpose of that ulterior motive? Was it something that the court could rule on anyway? No, the court could not, under the ecclesiastical abstention doctrine, say the ruling elders control the church, not the pastor. So what the ruling elders did was they made a complaint of unresearched, unverified, uninvestigated claims in order to defame our client, Pastor Maize, so that way he couldn't have time to respond. I'm sorry, I misspoke. So they filed it so it would make it become public. And before he had any chance to respond and to defend himself, they dismissed it on the merits. I think that goes to the abusive process claim as well.
Go ahead.
And then, as what I think is probably the most interesting part of this case, is the application of the ecclesiastical abstention doctrine. Here, there's a number of different issues, and I can only hit on the highlights. But I doubt the appellees are stating that there is an ecclesiastical abstention doctrine. There's a First Amendment right to abuse the process of the court. I don't think they are making that argument, and I don't think that anyone would make that argument. They're making that argument in regards to the defamation claims and the false light claim. The defamation claims, I'll say it like this: there is no First Amendment right to call someone a child molester, to make those defamatory false statements. We underwent in a large investigation. We investigated the person that they said that our clients molested, the underage minor. Well, that person was actually over the age of 21 and said they never had any type of sexual relationship. They knew.
Let me ask you a question. In the judge's final opinion on it's page 1808 of the record, the judge said it was conceded by the plaintiff during the summary judgment hearings that any such communications, this is referencing the Mason communications. As to the Mason communications, which was the elder communications, I think, with the Mason sisters, occurring within the walls of the church, it was conceded by plaintiff during the summary judgment hearings that any such communications would fall under the ecclesiastical abstention doctrine, both because they happened on church property and, more importantly, because the accusations allegedly made against the Mason sisters and plaintiff relate to his termination as senior pastor, which is undoubtedly an ecclesiastical undertaking. I didn't see any denial of that in your briefing.
Is that number 6 where I talk about a Scribner's error?
No, I mean, this is in the judge's decision. This is part of the judge's decision.
Right.
That's a finding that the judge made, that there had been a concession by the plaintiff during summary judgment hearings that any communications that occurred within the walls of the church would fall under the ecclesiastical abstention doctrine.
That is a fair statement to say. If it is done for the purposes of a religious purpose, for example, having a church service or the organization of the church, well, then that would be protected by the EAD. But there was a certain point when the church service stopped, and then the argument, the fight went from inside the church to outside the church. When that happened and it stopped being a religious undertaking, no, the ecclesiastical abstention doctrine does not apply at that point. I would have to go back and review that on page, you said 1808?
Yes. Yeah, that's part of the judge's decision. All right, well, you'll have your time left on rebuttal. the appellees. I'm not sure who's going to argue first here for the appellees.
Yes, Your Honor. Amy Peters. I'm the attorney representing Friendship Church, and yes, I'd like to reserve 10 minutes for my part.
So you're gonna take 10 minutes and Mr. Smith 5. Is that the way to work?
Yes, Your Honor.
Okay, very good.
So, in response to the plaintiff's comments, and I know that Your Honors have reviewed our briefs in the record, but some of the facts were left out. For contextual purposes, keep in mind that this is a religious body, a church that, in this particular denomination, it is ruled by a board of elders. So it is a church run by elders, not by a pastor. So in October of that year, 2014, the elders were presented with allegations from a Mr. Vincent Boozer, who was the assistant pastor. Mr. Boozer had just recently returned from an overnight trip to Alabama, which he had been asked to go on with Mr. Maize. And the purpose of this trip to Alabama was for him to appear and support the daughter of a friend of his, a young woman who had some criminal court trouble down in Alabama. And Mr. Boozer came back and told the elders that this young lady, who he believed to be underage, had spent the night in his hotel room, which he found to be morally objectionable. And so he put these allegations to the elders. As it turns out, we have taken the deposition of this young woman, and she was 21 at the time. It is undisputed that she was drunk to the point of not remembering many of the events of that night, and did in fact spend the night in his hotel room. She denied that anything happened. But so these allegations were put to the board of elders. Additional allegations were brought to the board of elders, and they determined that they were going to terminate the plaintiff's employment. They presented him with a letter advising him of that, which he refused to accept. They tried to present him with a second letter informing him of his termination, which he again refused to accept. He then appeared against their express instructions the following Sunday and conducted a church service against the board of elders' wishes, during which he took up a collection, including checks made out to the church, and took those and opened a separate bank account where he deposited those checks and then had access to those funds. He also admitted that he took cash during that collection, which he pocketed. This, of course, was against the church's bylaws. So at that point, after this service, that is when this complaint for injunction and declaratory relief was filed. And that is part of the court's record. It was attached as an exhibit to the plaintiff's complaint in our case. And as Your Honors will see when you read through there, that the issues with the money, in addition to the inappropriate interactions with underage women and other issues, were set out and set forth in that. Now, we have testimony from Mr. Maize, the plaintiff himself, admitting that he had had inappropriate communications with young unmarried women in his congregation. In particular, we have a string of Facebook messages that he was confronted with in his deposition, where he admits to telling her that he loved her and wanting to go away with her, talking about divorcing his wife. What we're getting into is the morality of a pastor, and that goes right into the ecclesiastical abstention doctrine. It has long been favored in our country and held that issues regarding morality, and in particular the fitness of a pastor to lead a church, fall squarely within the confines of the ecclesiastical abstention doctrine and would bar the court, in this case, from having subject matter jurisdiction to hear the claims. So in this case, when you read through the plaintiff's complaint, the allegations of false light and defamation, both libel and slander, involve these events that were happening during the church's attempt to have him removed as pastor. Because while he would like to say that he was terminated when that first letter was given to him in October, the fact of the matter is he adamantly refused to accept the termination and went on to continue coming to the church and trying to carry on this role to the point where they were forced to take action to get a restraining order. And with regard to the arguments that Mr. Blake testified to his knowledge, the fact is this verified complaint was based upon the church's and the elders' collective knowledge. Mr. Blake, what just happened to be the elder that was available that day to go down to the courthouse to meet the church's attorney to sign this and get it filed. But the complaint is him acting as an agent of the church, not him individually. And the record is replete with evidence that the church had a good faith basis for making all of the allegations in that verified complaint, in particular because they were made by Mr. Boozer, who was known to be a good friend and associate of the plaintiff and was in fact hired by the plaintiff. So they relied upon this information from him. And that's why it was not an abusive process for them to move forward to ask for injunctive relief to protect the church, not only from him taking more assets in the form of collections, but also to protect the church from civil liability in the form of a sexual harassment suit, when he had admittedly been saying to young single members of the congregation that he loved them and wanted to go away with them and that he would consider leaving his wife. Now, our position is that any statements, libel or slander, that were made during that week from late October to early November, which is all of the incidents outlined in the complaint, fall under the ecclesiastical abstention doctrine. And the trial court agreed with us, finding that it was clearly an ongoing process trying to remove him. So the ecclesiastical undertaking continued due to the plaintiff's willful refusal to accept his termination. And that's where this case differs from the Owlsley case that was cited by the court, because in that case, the removal was not fought, and then they continued basically gossiping about this person after the removal had occurred and had been accepted. But that's why it differs in this case, because he had not accepted it and was fighting the church. So the trial court, and we believe that's where this case is distinguished from the Owlsley case, and it would be appropriate to continue the ecclesiastical abstention doctrine protection through his actual removal from the church, which occurred after that. So then, with regard to the civil conspiracy claims, again, our position is that those claims are also covered by the ecclesiastical abstention doctrine. The decision regarding the removal of ministers and employment decisions affecting pastoral responsibilities are not subject to court review, period. That's what the Anderson versus Watchtower Bible case from 2007 has stated. And with regard to the plaintiff's claims that the reasons for his termination were pretextual for their true motivations, the Court of Appeals has previously ruled that the court can't parse out what was pretext and what isn't, because the fact is that the court would have to inquire into the correctness of the disfellowshipping or whether it was consistent with the church's religious doctrine and policies, and it can't do that because that's in direct violation of the ecclesiastical abstention doctrine. And so again, that would be why that is not covered. For the negligent infliction of emotional distress claims, again, we believe those are also covered by the ecclesiastical abstention doctrine, but we also state that the plaintiff did not have adequate evidence to prove the essential element of his claim that he suffered an emotional injury, that there was no expert proof. And at the trial court level, it was not really argued against that was the case. And in fact, on appeal, this is the first time that the plaintiff has ever made the argument that it was a parasitic claim. And so I would state that I believe that argument may have been waived because it was not offered at the trial court level.
Was it argued on the trial court level that it was a standalone claim? Is that the way it was presented at the trial court level?
That's my understanding, Your Honor. Yes. that it was a standalone claim.
All right. Go ahead.
Yeah.
Are you through?
I believe that's all that I had for you today, Your Honor. I'm going to cede the rest of our time to Mr. Smith, who represents the individual defendants.
All right, Mr. Smith? Is Mr. Smith frozen?
He's muted.
Oh, there we go.
All right,
I see him
there-
moving now.
Yes, okay. My name is Keenan Smith, and I represent the individual defendants who are, in fact, they were elders for the church. And I want to make sure that for housekeeping, we got all those. It's Robert Blake, Albert Russell, Arthur Foster, and James Hutchins. Now, James has not even been mentioned by the plaintiff that I saw anywhere in any of his documents that he's filed in this appeal. As the court might recall, Vincent Boozer has been dismissed by the court a few months ago. And then a gentleman by the name of Eric Finley was non-suited early on in the case. Now, as far as Robert Blake, Albert Russell, Arthur Foster, and James Hutchins, they were the first individuals to get out of this case. I'd filed motions for summary judgment on their behalf. We went back and forth a couple different iterations until we'd satisfied that the judge had received all of the information. And when I filed my motion for summary judgment on their behalf, the plaintiff made no response to my undisputed statements of material fact, made no response, basically just tried to argue that the statements made in the affidavits provided by Blake, Russell, Foster, and Hutchins were of opinions or conclusory. The judge rejected that. And so those individuals got out of the case about a month or so before the first trial, before we started with our trial. Basically, what I say is that the plaintiff just rolled over. He had no countervailing evidence. What my clients claimed was that they'd made no defamatory statements to anyone outside the church, period. The plaintiff provided no countervailing proof to that assertion. And therefore, we got out of the case. Now, later on, the plaintiffs have tried to make some additional emphasis on Brittany Mason. But Brittany Mason was not mentioned in being a part of any of the statements made in the initial in their complaint. In fact, Brittany Mason does not appear in their complaint. Now, what's interesting, and this can help organize everything for the court, the termination letter was given to Ezra Maize on October 27th, 2014. After that, Mr. Maize, as stated earlier, refused to cooperate with the church and accept his termination. Thereafter, there was a subsequent meeting on November 1st, a church service that was illegal and unsanctioned on November 2nd, and a congregation meeting on November 4th. That's the key period of time. During that time, that is when he was terminated, and there was an active resistance against his termination. All of the alleged statements made to Ms. Mason occurred during that time. It should also be pointed out that Ms. Mason she and her sister were the only ones present, and they knew whether or not they'd slept with him or not, or had massages with him or not. And therefore, by definition, if they didn't believe it, it's not defamatory anyway. And in this particular case, it all happened and is all protected under the ecclesiastical abstention doctrine. All the significant events occurred during that window, October 27th through November 4th, when he was terminated and there was an active resistance. That's when the statements were made. And all of those statements and activities are protected by the ecclesiastical abstention doctrine. That's what's key. Now, let me focus a little bit on the temporary restraining order and the injunction. My client was the individual that signed on behalf of the church. He was an elder acting as an agent for the church. When asked about his opinions about things, what he was most concerned about was he believed that Ezra Maize was a violent man, that he had threatened other elders at another church in Chattanooga, that he had exhibited great hostility and anger during the meetings with the elders. And therefore, Blake honestly said that his greatest concerns regarded and involved around any potential violence. But he also testified that all the other things that he signed off on, he believed that they were true. And imagine this, Your Honor, it's almost impossible to think that a pastor coming from some other place joins a church to be a pastor and then has no authority to handle money, to open a bank account, to take control of money. All of the bylaws of the church make that clear, yet he takes it upon himself to take up an offering at an unsanctioned service, go down to the Regions Bank, open up an account and take money.
Your time's up, Mr. Smith. Thank you.
Thank you.
All right, Mr. Weiss, you have 3 minutes in rebuttal.
Thank you. I think that the appellee's arguments here kind of proves our point. This case is not about the termination of a pastor from the church. It's irrelevant. It's a red herring. What this case is about is the Friendship Community Church and its agents, the elders, abuse the process of this court. And they abuse this process of the court by misusing and misapplying the process justified for itself. And the court can look at Gibbons versus Mulliken in this case. This was a power struggle between the elders and the pastor. And so instead of duking it out between themselves, the church went to the court and said many defamatory statements that were said in reckless disregard for the truth, unverified, unsubstantiated, and more importantly, uninvestigated. They don't just accuse of having inappropriate relationships with women. They called him having a child molester, a pedophile. There's no ecclesiastical abstention doctrine. There's no First Amendment right to call someone a child molester without any proof. And you can't hide behind the First Amendment to say, well, I can say whatever I want within the walls of the church. And so, Judge Golden, this goes to the question that you asked. The judge's order where it says that any communications by Miss Mason that occurs within the walls of the church that the plaintiff conceded would be protected by the EAD, that's not true. I'm glad the court pointed that out. I wasn't, I guess that part of it wasn't briefed entirely. What happens, just because a statement is made within the walls of the church itself does not necessarily mean that it's protected by the EAD. Now, if it's done during a church service, there's a good chance the EAD might protect it. But for a community social hour, I don't think that there would be any EAD because there's no religious purpose to it. It's just a community coming together. This case, again, is about...
Is it true, Mr. Weiss, that all of these communications occurred during this period of time when the termination of the pastor was occurring?
Directly preceding it and then mostly during it. Yes, Your Honor.
All right.
The question here is this court going to condone what the appellees have done in this case by abusing the process of the court, by calling a well-respected member of the community a child molester without any repercussions? I don't think that's the case. We're asking this court politely and respectfully to reverse the orders of the trial court and remand for a jury trial. Thank you.
All right, thank you very much. It's a very interesting case, and we'll get an opinion to you as soon as we can. Thank you very much for appearing today.
Thank you.
This honorable court is now in recess until 2:30 p.m. Eastern.